Start with chapter one, a legal framework for affecting public schools. So starting it off, the Bill of Rights represents a primary source of individual rights and freedoms under the United States Constitution, and the first 10 amendments to the Constitution are viewed as the fundamental liberties of free people because they place restrictions on the government's power to intrude on our fundamental rights. The restrictions simply mean that the government cannot exercise certain powers in relationship to free people. For example, the government cannot pass laws prohibiting the freedom of speech.
The federal Constitution, this is the basic law of the land of the United States, which provides a framework for how the processes of government operate, and the Constitution thus becomes the primary source of law. All states enacted at the federal, state, and local levels, as well as state constitutions and local regulations and ordinances, are subordinate to the Constitution. The federal Constitution is distinguishable in its provision to protect fundamental rights in all of citizens of the United States. Inherent among these rights are those involving personal, property, and political freedoms. Although the Constitution does not make a reference to education, it does impact the operation and management of schools, particularly with respect to amendments which protect the individual rights of students, faculty, and staff.
All right, now getting into the state constitutions. This is based on the 10th Amendment of the federal constitutions. Our powers are not delegated to the United States by the Constitution nor prohibited by it to the states and are reserved to the states respectively. Our state constitution represent the basic source of our law for individual states and generally require legislative bodies to perform various functions, including establishing systems of public education. This goes into funding and operational schemes for public schools. Our state constitution may exceed coverage granted by the federal constitution, but may not fail to meet the basic requirements of constitution or contradict it at any manner.
So then statutes are legislative acts that are the most abundant in school law or law that affects public schools. And school district policy, rules, regulations are all based on the statutory law. Statutes are the most effective means of developing new law or changing old laws. And our state legislators grant local school boards the power to adopt and enforce rules and regulations necessary for the operation and management of our schools.
With court and case law is generally reflected in a judge-made or common law, as distinguished from the statutory law. And then the common law consists of the judgments and opinions and decisions of the courts adopting and enforcing proceedings, usages, and customs called precedents. Should we talk about what precedents within precedents, a precedent can be set, but it doesn't have to be followed from jurisdiction to jurisdiction. The book talked about one case, there was a case in Florida that set a precedent, but because they were in a different jurisdiction, I don't remember what state it had said, but that state doesn't necessarily have to follow it because they're in a completely different jurisdiction. Sorry.
No, perfect. I was also wondering back on talking about statutes, I know our school handbook is everything in the handbook directly relates to all of the statutes. I don't know if every school district is like that, but I know mine is.
State Board of Education. So the State Board of Education are administrative agencies created by the state legislature. So they are separate. They're not the same. The state legislator and the state Board of Education are different individuals. They are the people who determine to some degree the direction of education in the state. Again, the legislature also has the ability to have a say in what education is like in the state. So both of these groups are kind of working together, or hopefully they're working together. And then the public schools are placed under the control of State Board of Education. State boards may develop policies covering areas such as health and safety, teacher licensure requirements, graduation requirements, and others that are relevant to the educational needs of this state. So those are a few things that the State Board of Education has. And then, of course, the legislature is responsible for making and passing all of the laws that schools and education has to follow.
So as Lexi just said, we talked about the state school board. Now we're going to break it down into more individualized, our local school boards. They make an impact on education policies, who the administration and supervisor is going to be within the school districts. They're involved with formulation of school district policies, which may be consistent with the state statutes. These policies may be accompanied by these rules and regulations that provide direction for operation of schools. So they have more of a distinct, they have to follow the same policies as what the state would provide, but they just bring it into more localized and create those policies within their school district.
All right, the U.S. system of courts. So we all should know there are three branches of government. The judicial system consists of federal and state courts. The way the courts are organized at both of those levels is basically the same. They're trials at court, intermediate courts of appeal, and then the Supreme Court.
And then the federal courts, they typically deal with cases involving federal or constitutional issues, or cases in which the parties are residents of different states. The federal court system includes district courts, terrible with that word, appellate courts, and the Supreme Court. And then there are 95 federal district courts in the United States. At least one federal court is found in each state, and larger states such as New York and California have as many as 4 federal courts. One thing I didn't, maybe it was the Supreme Court section I was interested in. Is there that they cover a broader area? That's probably on the next slide. I probably jumped ahead. All right, ready for the next one. Federal courts usually hear cases between citizens of different states. Oh, did we just read that one?
No.
Oh, and then cases involving litigation of federal statutes. Federal appellate courts are represented by the circuit courts of appeals. And then there are 13 federal circuit courts, including 11 with geographic jurisdiction over a number of states and territories. And one of the districts of Columbia, this is the one I was interested in, because Nebraska had, like, the one that we are in also has Arkansas in it, which kind of surprises me that it reaches down that far.
Yeah.
And then the primary function of the appellate court is to review the proceedings of lower courts to determine if there was any errors in law that were committed, such as procedural irregularities, unconstitutional misinterpretations, or inappropriate application of rules of evidence.
State courts. So state courts are part of each state's judicial system with the responsibility of hearing cases involving issues related to state constitutional law, state statutes, and common law. Many education cases are heard in state courts because they do not involve a federal question. I think that also has a lot to say with the federal government. Sometimes they kind of just step back from education and let the power rest in the states. And so a lot of times those cases will stay within the state and not always reach maybe the federal court.
Courts of general jurisdiction. So courts of general jurisdiction are often referred to as court or circuit courts. It covers most cases except for those that are held at a special court. And in many instances, decisions may be appealed from these courts to intermediate appellate courts or even to the state Supreme Court.
So courts of special jurisdiction generally hear legal disputes in special areas. They are referred to as trial courts with limited jurisdiction and may be called municipal or a justice of the peace, probate, small claims, or traffic courts. So basically anything that falls just outside the general court, more specialized, specific matters.
Intermediate appellate courts. These courts have emerged over the past 3 decades to hear appeals from trial courts or certain state agencies. So kind of focusing on that appeal section of it. Their primary role involves reviewing proceedings from trial courts to determine if substantive or procedural errors occurred in applying the law. So, I mean, obviously, we know what an appeal is, and that's what this was kind of based on, is to make sure that the law is being followed.
The Supreme Court. So this is our highest court in the land. There's no appeal beyond the decision of this court. The Supreme Court rulings can only be overturned by amendment of the federal Constitution. There's 9 justices. You have the Chief Justice comprise the High Court. Avoiding political infringement, they appoint to life terms. And cases reach the Supreme Court primarily in 2 ways: on appeal or by the writ of certiorari.
And that is pretty much it. Was there anything else anybody wanted to add to this?
I'll just speak a little bit on that last one where we talk about Supreme Court justices being appointed to life terms. I know, especially right now, that's kind of a hot topic, and that often gets a lot of debate in the United States, because when a president appoints them, they want to appoint someone who is in their same political party. So I think that's kind of something important to highlight on, and to know that that can cause some debate in the nation.
Well, I think it's interesting that they, to avoid political infringement, they're appointed to life terms, but, and presidents want somebody to have their same political leanings, right? But you're only president for 4 to 8 years, so
Yeah, I
I
agree.
find it very interesting.